SJC-12129, Rockland Trust Company v. Robert J. Langone.
This is the Bleak House case,
The case that has been around forever.
case that never ends.
Correct.
All right.
May it please the Court, Chief Justice Gantz, the other esteemed members of the panel. My name is Jason Morgan. I represent the appellant here, Rockland Trust Company. There are three areas of focus, at least from my perspective, as to where I think the Court needs to look at. The first was part of what the preliminary order had to deal with in terms of whether or not the Court should review this case under its power of general superintendents. Does it concern efficient administration of justice? Is it intended to correct and prevent errors and abuses? And does it fall in line, essentially, as a parallel to the Speroni's decision, albeit under a little bit different avenue? The second area that I'll focus on is whether or not the district court judge, Judge Bradley, committed legal error in holding that Rule 12b-10, which is essentially a codification of the Speroni's decision, does not apply to counterclaims, understanding that the other side in its brief seems to concede the fact that it does apply. We still have a legal decision out there and a legal issue for the court to decide on whether or not, in fact, it does. The third issue will be whether or not there was compliance by Rockland Trust Company with what is now Rule 12b-10, but also the parameters of Speroni's in terms of whether or not there was a timely objection made. An objection not just in the sense of a motion to dismiss, which I think is what has been focused on primarily by the other side, but also whether or not there was a timely answer and affirmative defense that similarly raised the issue.
Okay. If we can focus on the big issue, which is whether or not the counterclaim can proceed, what would you be asking for to be the consequence if you prevail?
What would have to happen, I think, is that the case would have to be dismissed, and then there is
Or the case would be dismissed, or the counterclaim would be dismissed?
The counterclaim would be dismissed and could be refiled under the rules. I think they have 30 days to then refile that claim in the Superior Court.
Okay,
Sorry.
now what happens if it were a compulsory counterclaim?
If it were a compulsory, I mean, I think the court has the discretion. I think part of the error here is the parties actually did a joint motion to transfer the case, which was denied by Judge Bradley. Again, I think based on the erroneous legal assumption that that a counterclaim can't be the trigger for pushing this out of the district court into Superior Court. What I think would happen is the parties could, or the court could, by its own, transfer the case, but the parties here have already agreed to transfer the entirety of the case to Superior Court in the event that the counterclaim has to be tried in Superior Court.
Do you think if the, let's assume that just following up on that, would you think that if there is a compulsory counterclaim and the counterclaim defendant moves to dismiss, is the judge compelled to do so, given that it's just a counterclaim, but the underlying claim doesn't require dismissal?
I don't know whether there's a legal requirement for the judge to do so. I think that there is certainly the discretion to do that, and I think focusing on the general administration and efficiency of justice, I think any court would do that, and I think the Superior Court could actually do the same. I think the Superior Court had the discretion to pull that claim, the initial affirmative claim, out of district court to try the claims together. So I think that there is certainly discretion. Whether or not it's mandatory, I don't know. I couldn't point to any legal authority to that.
How is a Superior Court doesn't monitor all district court cases?
He's saying if the counterclaim went, I think.
If the counterclaim went and it had the case and it had the parties, I believe that there is discretion to consolidate those two cases and pull the case out of district court. And here, again, it's sort of a non-issue because the parties had already agreed that we would consolidate the cases in any event if it went to Superior Court. In fact, we tried to collectively do that, and it was denied by Judge Bradley at the district court.
So nobody moved to keep it in the district court? She did that sua sponte?
No, we did a joint motion.
Right, to move it.
To move it.
Right.
And she denied it.
Oh, she did.
She denied our joint motion, saying that this is a counterclaim, and the counterclaim doesn't give any rights to push this out of district court into Superior Court. So
The theory is that the Superior Court would not have jurisdiction over it because it's still a claim of less than $25,000 in the complaint?
Well, I guess I'm confused by the decision as to why the joint motion was denied.
Didn't articulate the reasoning, I guess.
The argument, I think, is that in the district court's opinion is that the counterclaim itself can't be the basis for the jurisdictional amount.
I got the sense that maybe it was denied due to the protracted litigation and what's become out of a promissory note from 1984. I'm not saying that that's a legal analysis, but that seems perhaps to be what was going on. But as it relates to the $25,000 counterclaim, more than $25,000, the point's been made, I think maybe both of you agree, that with attorney voir dire, it makes a difference. It's not just a 12-person jury, but it's also attorney voir dire.
Correct, Your Honor, and we made that point in our brief as well, and we made the point to Judge Bradley as well, that the distinguishing differences between district court and superior court, leave aside all the statistics on, percentage of civil cases in district court and the numbers and things like that, is 2 points. One, you get a 12-person jury in superior court, and now you have voir dire
You have
in
the right
superior
to
court.
it in Superior Court, but you can do it in District Court.
A 12-person jury?
No, attorney-conducted voir dire is
Oh, voir dire.
permissible.
And as of 2015, it's allowed as of right in superior court, so there would
But
be,
it's
again,
permissible in
discretion.
District Court.
Permissible could be discretion of the judge, correct, Your Honor?
So both of you agree that Speronis applies, and you both agree that it should go to the Superior Court. Say we all agree with you. Do we decide whether the counterclaim was timely?
I think that there's two parts to that, and I think that there's also a subpart to that. Since the joint motion was denied, Mr. Langone, and you'll see in their brief, they no longer agree that it should go to Superior Court, I think is basically it. Or they're at least agreeing, they're disputing that the case should be dismissed and that it should make its way to Superior Court in that manner. I don't know if they would collectively still agree to a joint motion or not at this point. We tried that and it didn't work. When we tried to get the case dismissed, they obviously objected to that, even though we agreed to have it all heard in Superior Court. As to the second, so I don't know what their position would be on that at this point. But as to the second part of your question, Justice Budd, there would, I think, would be a finding of whether or not there was a timely objection. You referred to a timely
sorry.
motion to
Yes,
dismiss.
yes.
I think that's just one sub-part of it, and I think that's the only part that Mr. Langone is focused on. There are two parts, both under Speronis, and I recognize that we have a completely different panel than we had when Speronis was issued, and when Ziza was issued by Justice Botsford. I think you're the only remaining member of that panel. So we have a different makeup now, I appreciate, but essentially the rule holds, and I think the codification of Speronis in Rule 12b-10 essentially still says timely objection, and that can be one of two ways: a timely motion to dismiss or a timely raising of the defense in an answer. And I think we have both here. We certainly we disagree, and I think the large part of the brief focuses on whether or not there was a timely motion to dismiss, and I would suggest that we have the much better of the argument on that. But there's no addressing by the other side whether there was a timely response answer with an affirmative defense, and there's never been any finding or any indication that our answer wasn't timely. So we have two issues, and I think either one we win.
Just for the record, Chief Justice Gantz was also here for Ziza.
Oh, I'm sorry.
That's all right.
You wrote the opinion, and I forgot who the panel was.
I was very quiet, I'm sorry. Section 19.
Yes.
The actions may proceed in the courts only if there is no reasonable likelihood that recovery by the plaintiff will exceed $25,000. Any consequence of the fact that the statute speaks only of recovery by the plaintiff, referring to the complaint and not the counterclaim?
I would have to look. I thought 19A referred to counterclaim as well, but and that was the new thing that created the ambiguity in Speronis. But I would suggest, regardless, I'd say no. I mean, the Speronis, when it was codified in Rule 12b-10 is very clear, as is Rule 15 on amendments in terms of timing, and they both reference counterclaims
Right, but
equally.
I mean, if you go down that theoretical route, it's not that I disagree with you, but I do think the statute is going to trump the rule in every case. So if the statute only covers plaintiffs, the rule would not necessarily be conform to it.
I guess I would suggest, to the extent that we are looking at the legislature's imposition of Rule 12b-10 after Section 19 and 19A were implemented, it specifically includes counterclaim in there. The district court rules also talk about a counterclaim.
It's our
I think it
rule.
would be hard to not include a counterclaim as part of what you could use as a basis for dismissing. But
I don't disagree with you substantively. It's just that the rules aren't the legislature's, but.
Sure,
so we
understood,
can't- we can't-
understood. But I guess the point being, I don't think that there is ambiguity, even as we sit here today, between the two, and I think that there's nothing in 19 or 19A that would preclude that application to counterclaims, and I think the imposition of the district court rules 102A as well as Rule 12B10 specifically provide for counterclaims being the trigger as part of that, and I think it would be very difficult to interpret the language of that in any other way, and you certainly could rule that you could find them to be consistent, even if 19 spoke specifically to affirmative claims. You could certainly apply a consistency to those if you apply them back to back or side to side. Whereas I think there would be a contradiction between the two if you tried to say that it didn't apply.
As far as the timing issue, is your point as simple as, well, all that discussion as to whether or not the claim of damages has to be filed before the clock starts ticking doesn't really matter? All those pages don't matter because it's in the answer and that's enough?
Correct. I think we have two hooks, one of which is we have a timely answer, and that's a timely objection under both Speroni's and the rule, and I think that saves the day, if you will. Even if there was a finding that the motion to dismiss was untimely, which I think would be really hard to do under the set of circumstances that we have, I think the timely objection and the answer rules the day at the end of the day. And that's basically what the Speroni's court held. I mean, when this court, when you looked at that case, you basically said either a timely motion to dismiss or a timely objection and an answer. And in that case, what happened is almost identical to what we had here. The judge denied the motion to dismiss, saying, no, I have discretion, I don't have to do this. And then they filed a timely answer, and then they filed their Section 3 petition, and the court said, yes, under both scenarios, that was a timely objection under the rules.
You disagree, I think, with Mr. Langone about whether the damages are attorney's fees or not. You agree that attorney's fees can't make what gets it over the $25,000 cap, but you say that's not what we're seeking? Do I have that right?
Correct. I was very confused by Mr. Langone's brief because we totally agree that attorney's fees would not be an amount that would be included to get you over the $25,000 limit. It's based on when the case was filed and what were your statement of damages at that point, what were your base claim of damages. And when the initial case was filed, the base claim of damages was $6,500 in the counterclaim, which was ultimately dismissed and then resurrected. When the statement of damages was filed on October 29th of 2015, it was $110,000. And there's been a different counsel involved, and so I don't know if appellate counsel is familiar with the facts, but the statement of damages and the allegations in the amended counterclaim, the $110,000 is a base claim. It's based on a breach of contract claim, and amounts that they claim were essentially a $95,000 note plus interest. It has nothing to do with attorney's fees. So I would agree that if the whole claim, and if they were to acknowledge that, if they were to say that their whole claim is just attorney's fees, I'd be happy to go away with that. But that's not what their amended counterclaim says, and that's not what the statement of damages is based on. It's based on $110,000 as a base damages based on breach of contract and what I think is not even a count, but it's a fraud on the court count, which they claim justifies that same amount. But again, it's a base damages. That amount does not include attorney's fees. If you look at the correspondence that is included as part of the record, they would say that their overall claim actually exceeds $300,000 if you include attorney's fees. So we're talking about base damages of $110,000, and that's the only reason that we're here today. So I don't know where
I'm just trying to think precisely. So if you were to prevail, what would happen, you would say, is that the entire case would be dismissed?
Well, I think the counterclaim, the amended counterclaim, would be dismissed. And there would be a couple of different avenues that could happen there. One, the counterclaim could be dismissed, and they would have a right, I think, within 30 days to refile the identical claim in Superior Court without waiving any rights.
File it as a complaint.
Or they could choose not to and rest on their initial counterclaim of $6,500, which is what this case was tried on in the first place. And then I think either by agreement, which we had done before, or by discretion of the judge, If there was a refiling of the counterclaim for $110,000 in Superior Court, either the District Court or the Superior Court would have the discretion to consolidate those cases in Superior Court. But like I said, we've already reached an agreement to do that. We would agree to push our case to Superior Court as well.
And that would have to be done with the agreement, I believe, of the trial court chief justice, would it not, to have a consolidation of cases among two different courts?
You're probably right. I don't know off the top of my head what the parameters would be for that. But I do know that we reviewed this together not with appellate counsel, but with trial counsel for Mr. Langone. I see my time is done. If I could finish the question. But we did review this, and we both determined that there would be an ability for one or both of the courts at their discretion to consolidate the cases into Superior Court, which was the basis for our doing the joint motion. If there are no further questions.
Thank you.
Thank you, Your Honor.
Morning. May it please the Court, Dana Curhan for Robert Langone. I sort of assumed in my brief that the $25,000 limit may very well apply to counterclaims. I'm not sure about that. I know that the language, reviewing this, the language of the statute says plaintiff. If plaintiff is deemed to be
Plaintiff and counterclaim.
plaintiff and counterclaim, then it may be just a question of semantics. But, you know, the judge sort of as a fallback position said, by the way, counterclaims are not subject to this limit. She may very well have been right. I'm not sure.
Doesn't make a lot of sense, however, does it?
It may not. But this wouldn't be the first time that we had a statute with some ambiguity in it.
Oh, say not so.
But I think the main position taken by the judge was that the dismissal, the request to dismiss, was not timely. And I think she was correct in that. Just to give you a timetable, there was an earlier attempt to file a motion to amend in May of 2015. On July 8th, 2015, the amended counterclaim was filed along with a motion to allow its filing. The trial court allowed that motion on September 23rd. Rockland claimed that it did not receive notice of that until October 15th, but it then did not file the motion to dismiss until November 5th.
But what about the answer, however?
I'm not sure if the answer is timely. If you take the date, it should have been filed within 10 days of the service, and if you take that as September 23rd or even October 15th, the answer wasn't filed until November 25th.
The answer wasn't filed till November 25th?
The answer to the amended counterclaim.
And if you're right, and if the counterclaim cannot be brought, can they not bring it then in Superior Court as a complaint?
Statute of limitations.
They meaning Mr. Langone?
Yeah.
He probably can. I think it's his preference to leave it in the district court at this point.
Okay, so but you would say their objection to it would be barred, and they would have to proceed even if they would otherwise. All right. I mean, if that's the case, then we're not going to resolve the issue of whether or not the counterclaim matters in terms of $25,000.
I think that's probably right. You know, we're in a.
I'm sorry, I've lost you at, because Rockland Trust seems so certain, but you just disagree factually that the answer, forget the motion, the answer was separately filed and filed timely, but you say not.
I don't think so. I mean, I didn't really focus on this as an issue. Just looking at the date on it, it is November 25th.
For the answer?
For the answer.
Answer to the counterclaim?
The answer to the counterclaim.
And that was also the date for the motion? You say it's the same date?
The motion to dismiss was filed November 5th.
So you say it was filed before the answer to the counterclaim. Is that right?
That's correct. I think I'm right about that. And in the record appendix, these documents are dated. So it is November 5th for the motion to dismiss. November 12th, the motion to dismiss was denied as untimely. November 25th is when the answer to the amended counterclaim was filed. So I think
So the argument I take is that's within 30 days of when the counterclaim was filed? Right? Or 20 days or something?
I think their argument is that it was, but I think it's
Okay.
All right. Approximately two months after the amended counterclaim was accepted is when the answer went in. And the filing of an untimely motion to dismiss, my argument is that it does not toll the time period for filing the answer. So that's my position on that. I think
Could we go to the, you do agree, I mean, I read it in your brief. With respect, assume that for the, hypothetically, a case in which an answer or a motion or both were timely filed, you would agree that the counterclaim Spirones would apply? Yes?
I would. I think that's probably true. I'm not sure if I can. I sort of half conceded it in my brief, but I'm not sure if
I think you even got to 3/4, or maybe even.
Well, yeah, I think I assume that Spirones would apply, and there may be situations where it makes sense for it to apply, and this may be one of those cases. But I think just focusing on what the judge did.
That's what you think the judge did. It was a timeliness issue in your view.
It was a timeliness issue, and that's what the judge said. So, and I also think a judge could look at the, certainly attorney's fees, the $300,000 in attorney's fees. That is something that is not countable toward the $25,000. But as to the $110,000, it's not clear that the judge actually took a look at that, but a judge could look at that and say, well, okay, this is sort of like in law school when they talk about the usual million. The judge could look at this and say, okay, you're not very unlikely to get that, and could say, if all we're talking about is really the same claim that was in the original counterclaim,
The 6,000?
the 6,500, or something approximating that, then probably the case can stay here.
Okay.
So I think the judge certainly could have done that.
Since the clock doesn't start ticking because of the district court requirement that there be a statement of damages filed along with the complaint or the counterclaim, what's your response to the argument that really the time to respond with a motion to dismiss doesn't really start until after that?
Well, there's no case law that says that the language says does not say the statement of damages. It says the answer. I'm sorry, the counterclaim. It talks about the counterclaim. It doesn't talk about the statement of damages as something being critical. But what
Doesn't it have to be filed at the same time?
Well, it's supposed to be filed. I'm not sure if there's a consequence for it. I think it's like the Sears guaranteed 30-minute oil change. What happens if they don't make the 30 minutes? Too bad. You waited 35 minutes. I think that's and also when you take a look at the complaint itself. There's a very specific statement of damages. I think it's paragraph 31 of the amended complaint, of the amended counterclaim. Langone has suffered substantial damages, including the payment of $110,000 on a loan, and then approximately $300,000 in attorney's fees, and that's at page 219 of the record appendix. There was no question that Rockland was on notice of the amount of damages that were being claimed, and in fact, in May of 2015, when there was the first attempt to file an amended counterclaim, Rockland, in one of its pleadings, said, "Hey, look, they're now asking for over $400,000." I think there's no surprise, and I think what the language says, you focus on on 10 days of the filing of the pleading, not necessarily the statement of damages. Unless there are any further questions from the court, I will leave the remaining points of the brief.
Well, don't leave so
Okay,
quickly.
I'm still here.
Going back to the point that you don't contest, but which is frankly the reason we took this case, which is not to decide the timeliness of the filing, but the counterclaim issue. So do you agree with your brother that if there were a timely objection to the counterclaim, what do you say would happen? I mean, I'm looking to the efficiency of our procedure for adjudicating civil claims, and what do you say should happen?
I think if this had been a timely claim, the judge would probably have to do a more thorough analysis of whether that $110,000 is a real amount, or if it is what the likely value of the counterclaim is. I think the judge would probably have to do a more specific analysis
Okay,
of
if
that.
the judge comes to the view that it's over $25,000,
Then it may very well have to be dismissed, assuming
it being the counterclaim or it being the entire case?
probably the entire case. I'm not sure. There's not a lot of guidance in the case law on this.
Well, that's sort of why we took the case.
Yes.
You're going to help us as to what would be the most efficient way to resolve this for civil litigants so that these matters can be efficiently and cost-effectively resolved?
I think the most efficient thing to do would be to dismiss both the complaint, and the counterclaim. Keep them together. I can't give you much guidance on that, because I think we're in uncharted territory here.
I mean, the problem with that is you dismiss the case, and then they bring a case to Superior Court alleging less than $25,000, and the Superior Court throws it out because it's less than $25,000.
Well, not if this court tells them that they shouldn't.
But then you'd have to have the counterclaim essentially filed with the, you'd have to have the counterclaim filed with the
Right.
complaint in order for the Superior Court to know that it should not do that. I'm trying to figure this out, and you have to help us a little more than you are.
I apologize. I'm not sure how much help I can be. I can, what Justice Botsford said may make sense, but I don't think I can be much more help than that. And I apologize.
I mean, one
for that.
possibility is to say leave it in district court.
Well, that's what we actually asked for, and that would make sense too. Because the district court there's no jurisdictional problem with having the case remain in the district court.
The other possibility, it seems to me, is to work out some category of case to which the parties, if when you've got a counterclaim and there's a motion to dismiss and the judge has allowed it because of the jurisdictional amount, that there would be a procedure to seek the cross-court designation and do it that way.
That would make perfect sense. There is nothing in place right now that would allow that to happen. There's probably some sort of difficult ways of accomplishing that, but there's no easy way to do that at present.
It seems important, though, not this case, but say some other case that had protracted litigation and the parties want to get over yesterday's problems and on to tomorrow's to finish the case. I think that there's nothing wrong with the attorneys agreeing to keep the case in the district court, even if the counterclaim is more than $25,000.
I think that's right. And Mr. Langone is in his late 70s, and I think he'd like to get this thing over and done with. And I think the easiest way to do that is to leave it where it is and have it tried in the district court.
Okay, thank you.
Thank you.